Even though I'm sure all of us present today are very well aware of the esteemed chief guest repertoire, I still take this opportunity to share with you her remarkable and extremely luminous career. Honorable Miss Justice Hima Kohli was appointed as Judge of Honorable High Court of Delhi in the year 2006 and then went on to become the first woman Chief Justice of Telangana High Court and the ninth. And as if that was not enough, the ninth woman to be elevated to the Honorable Supreme Court in its history of 7 decades. Her deep erudition and powerful exposition of the principles of law brighten up the legal firmament of the Honorable Supreme Court of India, from which all courts in this country seek ultimate light and guidance. Honorable Miss Justice, during her tenure as a judge, has passed some remarkable orders and judgments that include protecting the identity of juvenile accused of crime, calling for inquiries into the detention of prisoners who had already been granted bail, provision of facilities to enable visually challenged people to study in the government educational institutions, and many more. Honorable Ms. Justice Kohli also monitored the Delhi government's response to the COVID-19 pandemic in India and gave directions to the central government and the ICMR for allowing and approving private laboratories to conduct testing in relation to the pandemic that paved the way for millions of people to get tested and be safe in one of the worst phases in the history of human evolution. Although we are, at this time, celebrating the International Women's Day, Innovation in Technology for Gender Equality, we cannot but help feel proud of the fact that India has the oldest judiciary in the world, and the role played by Indian women in the mitigation of the pressing issues facing the justice delivery system in India go back into antiquity to a period long before we started to acknowledge it. I take this opportunity to pay tribute to our esteemed judges for their continuous and untiring work done to mitigate the lasting feature of the rise in litigation in our country. We feel particularly honored and gratified with the presence of the distinguished dignitaries among us today. Honorable Justice Kohli.
Very good evening to all of you. My apologies that the program that was to commence a little earlier had to be delayed a bit, and you have been so patient and graciously waited. It was a little beyond my control. There was a set of professors from Oxford who Honorable the Chief Justice of India had invited to the Supreme Court, and I was one of the members in that committee. It is still going on. I took the liberty without any contempt, facing any contempt, of actually moving out of that discussion and joining you here. So again, my apologies. Mr. Bhatt, Senior Advocate, Mr. Nachiketa Joshi, Ms. Rashmi Singhania, Ms. Archana Pathak Dave, Mr. Bharat Kumar, Ms. Madhavi Diwan, Learned ASG, Mr. Khanna, Senior Advocate, I can see Mr. Ghosh, Senior Advocate. There are so many of you here who I can name. I wouldn't. Otherwise, we'll be here till dinner time, I guess. But it's a pleasure to see all of you, advocates, friends from the media, ladies and gentlemen. I start by complimenting the organizers for selecting this nuanced topic for discussion. Mr. Bhatt did touch upon it. Ordinarily, we talk of equality and not necessarily equity. So, this is my thought process that I share with you. The Indian justice delivery system has long stood as the bastion of equity, equality, and access to justice for all. At its core, the system seeks to ensure fairness, impartiality, and justice in the distribution of benefits and burdens. The Constitution of India guarantees the right to justice as a fundamental right, and the Indian judiciary has no doubt played a pivotal role in upholding this promise. The subject of this addresses concept of equity and how courts have ensured fairness and impartiality in the justice delivery system. So most of us and many people mistake equity for equality and vice versa. But that is not so. One must recognize that equity serves as the vehicle that propels us towards the ultimate goal and destiny of equality. Interestingly, the word equity has not been mentioned in the Constitution at all. Yet it permeates the very essence of a fair justice delivery system. Equity is not recognized as a constitutional principle in the Indian legal context, but as a consequence of meticulous and discretionary judicial scrutiny and interpretation. It has a distinctive ethical equality that guarantees just consequences in a case. I would also like to share with you, when if you go back and just run through the Constitution, the word equality is used thrice, once in the preamble and a couple of times in the part 3, the fundamental rights principles. And yet again in part 5 and 6, when the references to the state and the union and the parliament and the legislature in the context of equal vote, but equity is not mentioned at all by the constitution makers. Equity is often described as a fairness or justice in the distribution of resources, opportunities and benefits. In the context of the justice delivery system, equity would mean that everyone is treated fairly and each one has equal access to justice. True equality cannot be achieved without equity. This is because equity requires more than just equal treatment. It calls upon us to recognize and address the systemic barriers and discrimination that prevent the oppressed, the exploited, and the marginalized communities from accessing the same opportunities and benefits as others. It recognizes that different individuals and communities have different needs, they have different experiences, and that equal treatment may not necessarily result in equal outcomes. The principle of equality is that golden rule that is imbued in the very soul of the Indian justice delivery system. It stands for fairness, egalitarianism, impartiality, and a just distribution of benefits and burdens. The principle of equity ensures that justice is delivered fairly and impartially. You just heard Mr. Bhatt's narrative of that debate, and what are the words he ended with? That the wife of one of the participants who went to participate, Mr. Mishra, was fair and impartial. And that is what equity is about. So while the Constitution of India guarantees the fundamental right to equality and prohibits discrimination on grounds of race, caste, religion, sex, place of birth, the principles of equity is that natural law recognized by courts which ensures that all individuals are treated equally under the law and have equal access to justice. To quote Dr. Naheem Dosani, a palliative care physician who has summarized the distinction between equity and equality so simply, and I'm sure it'll appeal to you. Equality is giving everyone a shoe. I repeat, equality is giving everyone a shoe. Equity is giving everyone a shoe that fits. And that is the fine distinction. The role of the Indian judiciary in promoting equity. The Indian judiciary has played a pivotal role in promoting equity in the justice delivery system. The power of judicial review exercised by the Supreme Courts and the High Courts allow them to strike down any law or executive action that violates the Constitution or the fundamental rights of the citizens bestowed under the Constitution, and has expanded through time by meaningful judicial interpretation. The judiciary has also jurisprudentially developed various principles of equity to ensure that justice can be delivered fairly, impartially, and objectively. So one of the key elements of equity is access to justice. Every individual must have access to legal remedies regardless of their social and economic standing. Achieving equity in access of justice in India, to my mind, is a social call. We as a society must address the challenges that stand in the way of ensuring that every individual has access to legal remedies. One of the most significant barriers to access to justice in India is the lack of awareness of legal aid programs being run by NALSA, by SALSA, and several other organizations like the Parishad. After we've just been told how many of programs they have organized and how they have reached out to assist those who are in need of a legal assistant. Legal aid is critical to ensure that individuals who are unable to afford lawyers can still seek legal recourse. This includes providing free legal aid to those who cannot afford it and improving the infrastructure of the existing legal aid programs so that they are accessible to all individuals, particularly those living in remote and inaccessible areas or rural areas or are not aware of their rights. To share with you some data, the data reveals that in the current financial year, from April to December 22, 3.88 lakh legal awareness programs have been organized by NALSA and SALSAs across the country that have been attended by 5.74 crore persons. 2,16,000 odd persons have been extended legal aid through panel lawyers. 4,70,000 persons have been given legal advice and counseling, and almost 2 lakh persons have benefited through other legal services. But when we look at our vast population, all this seems like a drop in the ocean, and we will have to say that this is work under progress. Another significant challenge is the long delays in the justice delivery system. We all hear about it, and in being part of the legal fraternity, often this question is posed to so many of us, both on this side and that side, particularly lawyers who have to contend with their clients wondering why their cases are not being taken up, why are they not being disposed of, why are they not being heard. To address this challenge, an increased focus is required on streamlining the justice delivery system and reducing the backlog of cases. There are several reasons for the mounting arrears. This includes a skewed judge population ratio, a large number of vacancies, a high inflow of cases, increased citizen awareness of their rights, lack of infrastructure to set up courts, and the enactment of new legislations. I may hasten to clarify here that a pending case does not automatically add to the arrears unless and until it crosses the acceptable timeline for its disposal, depending on the nature of the litigation. It is also important to recognize the role that technology has played in improving access to justice, and all of us have been beneficiaries of that, particularly during the COVID times, and even now through the hybrid mode. The use of AI, such as online dispute resolution mechanisms and virtual courts, have gone a long way in streamlining the justice delivery system and making it more accessible to individuals situated in remote and rural areas. Expanding the digital footprint in this area is imperative, and that is also a way forward. Coming next to the application of principles of equity in prominent cases decided by the Supreme Courts. The Indian judiciary has applied the principle of equity in several judicial verdicts. Since we have assembled today to celebrate the International Women's Day, permit me to highlight a clutch of women-centric decisions that demonstrate that application of the principle of equity can ensure a fair and impartial outcome for the society, and more particularly, achieve that equality goal for women. I'll start with the well-celebrated Indira Sahni's case, which is a significant case in that the issue of reservation in India was highlighted. The Supreme Court had upheld the validity of reservation for the SC and the ST in public employment and educational institutions. It was observed that the principle of equity required that affirmative action should be taken to redress historical injustices and ensure that all individuals had equal access to opportunities. The court observed that reservation was necessary to address social and economic inequalities faced by the SC and ST communities and to ensure that they had equal access to public employment and education institutions. It was also opined that reservation was a tool for achieving social justice and was a legitimate means to overcome the effects of the historical discrimination and social exclusion. Another case, Vishakha and others, was the state of Rajasthan. This was a case of the year 1997, a landmark judgment. It dealt with the issue of sexual harassment of women at the workplace and recognized that it is violating the fundamental right of equality guaranteed under the Indian Constitution. So this was again an expansive interpretation of the fundamental right by the Supreme Court. The court had laid down guidelines to prevent and deter sexual harassment at workplace, including requirement for employers to establish internal complaints committees, the prohibition of retaliation against complainants, and the obligation to provide a safe and secure work environment for women. This case has had a profound impact on the subsequent legislation that led to the enactment that took place in the year 2013. So the guidelines were good from the date of the pronouncement of the judgment till the legislation took place in 2013. And it couldn't be more innovative. Incidentally, every court has an internal complaints committee. You're all aware of it. We recently, on the occasion of the International Women's Day also, as chairperson of GICC, I thought we should celebrate this particular occasion. It was such a pleasure to see so many of you participate as audience in that play that was enacted by none other than advocates and in a song that was sung by none other than the staff of the Supreme Court. The third case that I propose to highlight is the Geeta Hariharan case. In this case, the petitioner, a married lady with a son, had applied to the Reserve Bank of India for bonds to be held in the name of the minor's son, and she had signed the application as his guardian. The RBI had turned down the application and told the petitioner to either forward the same signed by the father or produce a certificate of guardianship from a competent authority in her favor. The assumption was that the petitioner's husband was the natural guardian of the child, which was based on Section 6A of the Hindu Minority and Guardianship Act. Upholding the plea for gender equality enshrined in the Indian Constitution, the CEDAW and UDHR, the Supreme Court had given an expansive interpretation to the word after in the provision 6A and had upheld its constitutional validity by declaring that both the father and the mother are natural guardians of a minor Hindu child, and the mother cannot be said to be a natural guardian only after the death of the father, as that would not only be discriminatory, but will be against the welfare of the child, which is the legislative intent of the Act. The third and a recent judgment is of July 22, 2022 that I propose to share in the case of Akela Lalita. The Supreme Court has declared that a mother, being the sole natural guardian of her child, has the authority to determine the child's surname, even after the death of her first husband. She cannot be prevented from including her child in her new family and selecting the surname of the child. The court has also asserted that natural guardians possesses the power to give the child up for adoption. I come next to the Air India Cabin Crew Association case, which was of the year 2003. Here, the Supreme Court, while acknowledging the fact that the Constitution forbids the state from discriminating against citizens based solely on their gender, clarified that this prohibition does not prevent employers from providing special treatment to women in employment if they request it. The Constitution also permits employers to consider the gender of the employee when making employment decisions, if it is a part of the legally authorized affirmative action plan. Reiterating the fact that Articles 15 and Article 16 of the Constitution do prohibit discriminatory treatment, it was clarified that they do not forbid preferential or special treatment of women, which is a beneficial measure. The conclusion was that a regulation that discriminates based on sex to safeguard women's interests cannot be treated as unconstitutional. I now come to the case which we know as the dance bar case. The title is Indian Hotels and Restaurant Association. This was a case decided in the year 2019. This case dealt with the constitutional validity of certain provisions of the Maharashtra provision of obscene dances in hotels, restaurants, etc., and protection of dignity of women at workplace. It's a 2016 Act, and the rules framed thereunder. The case challenged conditions imposed under the Dance Act. The Supreme Court held that the applications for the grant of a license should be considered with an open mind and without imputing any moral standards, so that there would not be a complete ban on staging dance performances at designated places. It was declared that an absolute ban on dance performances in bars throughout the state was illegal and infringed upon the fundamental rights protected under Article 14, 19 and 21 of the Constitution. As a result, the Supreme Court upheld the ban on obscene dances, and that included showering of currency notes, etc. on dancers, but at the same time, it struck down the ban on serving alcohol in dance bars, as also the enforced separation between discotheques and dance bars, and conditions relating to the character of the person applying for the license. Really speaking, it recognized the right of a woman to go for a vocation which she wanted to, without legislative impediments. I come next to the famous Babita Punia case. A recent and an immensely significant milestone is this decision to provide permanent commission to women who were earlier offered only short service commissions in the Indian Armed Forces. This landmark judgment has emanated from a judgment of the Delhi High Court rendered in the year 2010, finally upheld by the Supreme Court in 2020, and has highlighted the importance of fairness and equality in all spheres of the armed forces, including the process of commissioning and promotion. Senior Advocate Bala, we still call him Captain Bala, is here, and he's been through the whole road from day one till the matter actually ended in a judgment, and the lingering issues which continued till as recently as 3 months ago, which have been brought to a closure in this case. And I'm glad to share with you, which I was told at a recent Armed Forces conference which was conducted, that against 2,500 vacancies, I was told more than 1 lakh women have applied this time in the armed forces. So this decision is a testament to the growing recognition of the value that women can bring to the armed forces. Offering permanent commission to women is not just about fair play and equity, which are priceless virtues in their own right. It is also about recognizing the unique skills and abilities that women bring to the armed forces, which is a different perspective, a different set of experiences, and a different set of skills on the table. Lastly, one more. Arunachal Gowda, one more before the last. In 22 of January, the Supreme Court in this case determined the self-acquired property of a Hindu male who dies without leaving a will would be inherited rather than succeeded, and his daughter would have the right to inherit such property. This decision reflects a succession scheme that prioritizes the daughter's rights to her father's separate property in line with the principles of proximity and equity. The judgment establishes a scheme of succession that is in alignment with the rule of proximity and entitlement of the sole surviving daughter to her father's separate properties, even as far back as prior to the enactment of the Hindu Succession Act 56. Overall, this ruling is consistent with the concept of equity in the Hindu succession law, aimed to distribute property in a fair, equitable and just manner. Prior to this deliberation, in August 2020, in the case of Vineet Sharma, the Supreme Court has expounded on a Hindu woman's right to be a joint legal heir and inherit ancestral property on terms at par with male heirs. Lastly, X versus Principal Secretary Health This is a recent landmark ruling pronounced by the Supreme Court in September last year, where it has affirmed that all women, regardless of their marital status, have equal access to safe and legal abortion up to 24 weeks of gestation. The decision is a significant step forward for gender equality and reproductive rights in India, and sets a powerful example for other countries facing regressive trends in abortion access. By recognizing and protecting the woman's right to choose, regardless of their marital status, the court has taken a critical step towards promoting gender equality and justice for all individuals, regardless of their gender and social status. Overall, this ruling reaffirms the principle of equity in healthcare and underscores the importance of ensuring equal access to essential medical services for all individuals. It is a significant step forward for women's rights in India, bucking the trend in other, even developed parts of the world where abortion access faces new restrictions. Significantly, and that is the point I will make after referring to all these judgments, except for the Vishakha case, where the 5 judges bench included a woman judge, all the remaining judgments that I have just referred to here do not include a woman judge. The author of these judgments are male judges, and the benches were all male. So this shows that the stereotypes in categorizing men and women should be avoided. The word she does include he, and her does include he, and it is the men who are forward-looking, who are evolving this jurisprudence and expanding it through judgments, who must be congratulated and acknowledged for this. And I would be failing in my duty to recognize that even today, in a house full, the majority are men, and that is how we celebrate the International Women's Day. To conclude, equity is not just a buzzword or a slogan. It is the very foundation on which the edifice of truth is built. Without equity, equality will remain a pipe dream. To achieve true justice and fairness in our society, each individual must have equal access to opportunities, and everyone must be treated with dignity and respect which they deserve. The Indian justice delivery system has evolved over the years, and we have all been part of that growth. And the principles of equity and justice have played a crucial role in this evolution. The Supreme Court and High Courts have been instrumental in upholding these principles and laying down several guidelines and precedents to ensure that justice delivery system remains just, remains equitable, thereby working towards the equality goal. As we celebrate the International Day of Women, it is a time for us to reflect not just on the 8th of March of every year or the month of March of every year, but throughout the year on a role that equity plays in achieving true justice and equality in our society. Equity is the cornerstone of a just and fair society where every individual gets the same opportunities, the same resources, and benefits regardless of their gender, their race, their ethnicity, or their socioeconomic status. It is a cardinal principle that ensures that everyone is treated fairly, impartially, and that no one is left behind in the onward growth of the society. It is a recognition of the fact that women, who constitute almost 50% of the total population in India, are going to dominate the workforce in the next few decades, are given their place under the sun, that they enjoy equal rights and privileges at par with men, that they are not oppressed mentally, physically, or emotionally, that they are empowered to fight for the goals they choose to set for themselves, that their dreams can take wings, and that they can freely march to the beat of their own drum. Thank you.